So, hello everybody. This was supposed to be the first episode of Maxime and I's weekly news and case update on private client matters, but unfortunately, I screwed the lighting up because I was actually in Singapore at the time and I didn't realize that the sun was going down behind me. So, anyway, I've re-recorded this, our first episode, on my own, and it's a great case, and I hope you enjoy it. And then we'll bring in Maxime next week for episode number two. Thanks very much. Okay, so hello everybody. So my name is Ross Ballom of Ballom Law, and today I'm going to do an update on a decision that's come out of the European Courts of Human Rights recently, and that involves forced heirship. So forced heirship isn't something that I talk a lot about. As many of you will know, forced heirship is a civil law concept. That is, it's more found in the European legal systems that follow the Napoleonic legal tradition, as opposed to the more Anglo Saxon common law systems. And this decision involved a long running dispute regarding a very famous composer. So it involved a gentleman known as Maurice Jarre. He's a renowned composer of music for such famous films as Lawrence of Arabia and Dr. Zhivago, and he won many Oscars, I understand, also for his work. He also has a very famous musical son, Jean-Michel, who's very well known for his concerts. And Maurice Jarre was married many times, and at the end of his life, he decided, it appears, to leave all his assets to his current and fourth wife. And he made a will in 2008 where he did indeed leave all of his movable assets to this last wife, and for the remainder of his assets to also go into a trust for her. And he expressly excluded his two children. Now, this case has similar effects to the French singer Johnny Hallyday. You have these French citizens who are involved in the music and entertainment industry out in California and then make that their home and then apply Californian law to their estate. And then you have some heirs back in France who have something to say about that and may have benefited better if French law had applied. So really, this is all about a conflict between Californian law and French law and French heirs that felt they have not been treated correctly. And I have a lot of sympathy for the children in this case. I mean, clearly this is not about money. Jean-Michel Jarre, I suspect, probably more wealthy than his father, a very successful musician in his own right. But where I think the emotive issue here is that the children were excluded from receiving dad's intellectual property. They were excluded from having ownership over all of his legacy of his music and compositions. And I can see how that might have hurt the children and why they fought so hard for this. I don't know if the children were looked after financially outside of these arrangements, but in any event, I can understand why they fought this so hard, even going as far as the European Court of Human Rights. So let's have a look at what was decided. Now, an important thing to state up front is that forced heirship has been reduced by what is known as the EU succession regulation. This came into effect in August 2015, and it essentially confirms that the place of the last habitual residence governs the succession of both movable and immovable property and permits an individual to make a choice as to what might govern their succession, even an ability to nominate the law of their nationality to that succession. And Maurice Jarre was habitually resident in California when he died. And so even though we have an EU state and a non-EU state in conflict, the EU succession regulation did apply. And then this meant that even French citus assets which were movables could be governed by Californian law. Now, what happened was that the children had a High Court application in 2015 dismissed. The French Court of Appeal rejected further their arguments in May 2016. And then in September 2017, the Supreme Court upheld the decision of the Court of Appeal. So they were very desperate. and their final fight was that they went to the European Court of Human Rights, and that ruled recently against them as well, ending their claims basically. Now, what did they argue? They made three arguments. First of all, they argued that the forced heirship rights of children should be treated as a matter of international public policy and not of mere internal public policy. So this is a very opaque argument, a very complex conflict of laws arguments. Essentially, they were arguing that Californian law should not be applied, and that it was for the good of not just French citizens but also international citizens that forced heirship should apply. And they even trotted out the fact that the French Revolution of 1789 curtailed testamentary freedom as a reaction against the aristocracy of the time. So they were clutching at straws with their first argument. The second argument was that they dug up a law from 1819, which argued that where an inheritance is deemed under a foreign law to be lower than that would have been received under French law, the heirs have a right to receive a supplementary share of the French assets. Now, that again was dismissed. And then their third argument was my old friend, the sham, as I always find, it's always thrown in as a last-minute desperate attempt when all the arguments don't fail, and no surprise to see it here again, even in French international law disputes. But they try to claim that there was an SCI transaction, which means that Maurice Jarre had put a French apartment into an SCI. I think I'll do another video on SCIs. They are the French companies essentially that are used to hold real estate. But they argued that this transfer of his French apartment into this SCI, which was then put under the Californian trust, was a sham, and that it had no real substance and nor life as an independent entity. So these arguments were rejected, all of them outright, by all of those courts. I mean, French law, they really do understand trusts, actually, the French, and they fully upheld the Californian legal rights of the settlor, of Maurice Jarre. They upheld the trust, they upheld all the transfers into the trust, and they found that the argument around whether Californian law should apply was not debatable. The EU succession regulations made that quite clear. So they really upheld that the EU succession regulation and the right of Maurice Jarre to choose Californian law to apply to his assets, even his French assets. And they further found that the 1890 law was not an essential principle of French law, that really forced heirship was not an essential principle of French law, and was therefore not protected by the international public policy argument. And they further rejected the fact that the SCI was some sort of sham transaction, interestingly, because they noted that it was a continuous and careful succession and estate plan that the father had put in over many years. So that sort of suggests that being able to evidence that what you're doing is part of a broader, carefully thought out, built up over many years estate plan will aid the validity of your structure. The Supreme Court also did note, though, that they might have come to a different decision if the heirs didn't have any assets of their own, and if they were poor and they were being disinherited in that way, if there was any financial hardship, or if they weren't of legal age, they might have come to a different decision. So perhaps it might have gone against the children that they had money in their own right. But as I say, we don't know whether they were looked after outside of the estate by Maurice Jarre. So this might have counted against them in some way. And then just to conclude then, the European Court of Human Rights rejected the children's arguments that they had their human rights to a fair hearing under section 6.1 of the ECHR, and their right to protection of property under Article 1 of the ECHR had been violated. That was outright rejected, and ECHR concluded that children do not have a general right to inherit from their parents. So interesting decision there. Celebrities often giving us this opportunity to see what the courts and the laws are thinking. And so I hope you enjoyed this video. Please do the usual like and subscribing and sharing, and I'll see you on a further update.